Tonight, a doctor in Queens stands accused of doing the unthinkable, drugging and raping unconscious patients, and in some cases, filming it.
He was convicted of murder in the 3-year-old death of Asen King. This was from a road rage incident.
He's been crying since he was arrested.
Victor Garcia Herrera, the owner of a pet boarding business in the Valley, is in jail. A judge convicted Garcia Herrera on animal abuse charges after he agreed to a plea deal.
In accordance with the laws, judging you guilty of the crime of attempt cruelty to animals or gross misdemeanor.
Judge Christy Craig made her decision in court, noting that Victor Garcia Herrera faced charges of attempted animal cruelty. Garcia Herrera's charges came after several dogs died at or shortly after being at his pet boarding business in the East Valley. This included Moore, a dog rescued by Gina Grace of Nevada Voters for Animals, who died after several days in July.
We tell owners to trust us, to give your pet a better life by putting them into rescue. Then we trust others to care for these precious souls.
The judge made it clear that Garcia Herrera cannot work with or be around animals, including his own 3 dogs, for the next 5 years.
I have to place the dogs someplace else, and you can't visit with them or anything, you understand?
Garcia Herrera reached an agreement with the district attorney's office known as an Alford plea. This means he pleads guilty but maintains his innocence, acknowledging that the evidence is strong enough that a jury would likely convict him beyond a reasonable doubt. He stated he made the deal to protect his family's safety following harassment on social media and vandalism of his business, which will now be run by his wife. Garcia Herrera continues to deny any abuse occurred on his part. Grayson and other animal activists urged the judge to shut down the business, expressing concerns that abuse could still happen soon.
To find out that the wife is just going to run it, and to me this is only worse now, because now it's one less person there to help run this facility that is, I will say, a house of horrors for animals.
Judge Craig stated that closing a business is not within her authority. She sentenced Garcia Herrera to a 1-year suspended prison sentence to be served through probation, with the first 11 days to be served in county jail. An emotional day in court as a man convicted in a deadly bar beating was sentenced for murder. The victim's family delivered a message to the murderer. Outside the courthouse, the victim's mother shared that it could happen to anyone. However, she felt that justice was served. Paul Fahey, 44, stood before a judge to be sentenced for second-degree murder. He was convicted of killing Keith Boudreaux, a man at a sports bar, back in 2015.
The jury understood exactly what people were saying and came back in less than 2 hours. It was, to us, that was kind of remarkable.
Calling him a cowardly bully, the victim's family said he was unprovoked when he punched the father of 2 in the face and then stomped on his head inside the sports bar.
I miss my son more than anyone could ever imagine, but I find great strength in knowing that he was a decent man.
Before he was sentenced, members of the victim's family addressed the court for a victim impact statement. His mother was the first to speak, paying tribute to the son she lost.
I used to say to Keith, "Be careful out there, Keith." And he always said to me, "Mom, I don't make enemies, I make friends."
The kind of person who has literally taken his shirt off of his own back to give to someone else. The damage you have caused to his 2 young boys is unspeakable. I hope that night plays out in his mind over and over and over and haunts him for the rest of his life the way it does to us.
Mr. Fahey, in closing, God forgives, I don't.
Fahey showed little emotion in the courtroom until his attorney read a letter from his son to the judge, expressing that he was always there for him as a father. Fahey is now sentenced to prison and will be eligible to apply for parole after 15 years. Tears and a denial from the man charged with killing his wife. Police say that Andrew McCormack strangled his wife and attacked her with a knife, killing her in their Revere home. However, McCormack insists that the real killer is still out there.
Mr. McCormack lived in a single-family house in Revere with his wife, Vanessa.
He mouthed, "My baby," and strained to see the baby carriage in Chelsea Court, where he was surrounded by his murdered wife's family.
Our belief is that the baby was in the house at the time of the murder.
Andrew McCormack is accused of killing his wife, a second-grade teacher, in their home.
She had both slash and stab wounds on her neck. She had signs of both manual strangulation and suffocation, the latter possibly from a trash bag that appeared to have been put on her head at some point.
The criminal complaint filed in court shows that the last phone call Vanessa made from her cell phone was at 8:35 a.m. to her husband on the day of the murder. A text was sent a little over an hour later, followed by a flurry of missed calls and unanswered texts from her family for the rest of the day. Prosecutors say a cocaine dealer reported that Andrew McCormack had a $400 to $500 a week drug habit and bought $100 worth of cocaine on the day of the murder. Texts from Vanessa last month included messages saying, "I hate you so much," and that she had looked into divorce lawyers. At the murder scene, McCormack was visibly emotional. Prosecutors also noted that the house smelled of bleach and he had a skin rash.
Bathroom across the hall had been scrubbed spotless.
But as McCormack appeared to sob,
He's been crying since he was arrested.
his defense attorney called the case circumstantial and urged the public to reserve judgment. The daughter of Trooper Thomas Clardy gave a victim impact statement before the man convicted of killing him was sentenced. David Njuguna crashed into Trooper Clardy on the Mass Pike in 2016. The judge sentenced him to 5 to 7 years in prison. However, Njuguna will be eligible for release sooner, as he will receive credit for the 3.5 years he has already spent in prison.
I'm sorry I cry every night, and I'm sorry that I'm not happy. I know you would want me to be.
Clardy's wife read a heartbreaking apology from one of their devastated children, expressing grief over the loss of their husband and father, Tom Clardy, and the profound impact his absence has had on their family.
As I look at my children, they look healthy and well. They are not the same children I knew 3 years ago. Their smiles are not as big, their laughter not as strong, and their hearts empty without their father's love.
The youngest of Clardy's children, too young to remember much, lost their superhero dad 3.5 years ago. David Njuguna, 33, slammed into the state trooper's cruiser on the Mass Pike in Charlton, the road Clardy patrolled and protected. Njuguna was convicted of involuntary manslaughter, but the judge said prosecutors did not prove he had been high on marijuana.
Exactly is what David Njuguna did more egregious than the guidelines? Is it because it involves Tom Clardy? It shouldn't be, and you know that.
Despite prosecutors' requests for 10 to 12 years, Njuguna was sentenced to 5 to 7 years. The judge acknowledged that no sentence could bring Clardy back. His children are left missing him and leaning on each other in their immense grief.
My dad was my hero. My dad made us laugh, never caring what others thought. He would do anything just to make us.
I'll continue for her, if that's all right.
Alyssa Clardy released a statement thanking the state police who supported the family in and outside the courtroom throughout the trial. She said Tom would be humbled to know that his fellow troopers continued to look out for his family. The charges continue to pile up against this Queens gastroenterologist. Dr. G. Allen Chung faced his third indictment. He is accused of using his position as a physician to commit sex crimes against both patients and non-patients.
He targets people that are helpless.
She said she was sedated for a routine colonoscopy, and when she woke up, Dr. Ching was assaulting her.
I was in the recovery area with the curtains drawn, and Dr. Cheng was giving me a vaginal exam.
The Queens DA said Dr. Chung drugged and sexually abused or raped more than 14 women. Many of them, investigators say, are seen unconscious in videos recovered from the doctor's possession. Attorney Nicholas Leokas represents several of the alleged victims.
One of the first victims that came forward was not aware that she had been raped or victimized until she was shown a video by the district attorney's office.
I reached out to the Queens DA. They showed me a screenshot of one of the videos he had, and they asked me to identify myself, and I did.
Many alleged victims are now suing New York Presbyterian Hospital Queens, claiming the hospital should have detected Dr. Chung's behavior as early as 2021. This was when a 19-year-old patient reported being drugged and raped on video inside a hospital exam room.
I am scared. I no longer want to go to hospitals.
New York Presbyterian Hospital said they fired Dr. Chung upon learning of the criminal case and issued a statement expressing deep sorrow for the victims and their families. They described the additional charges as horrific and emphasized their commitment to working with the district attorney to advance the investigation and ensure justice is served. Dr. Chung has pleaded not guilty to all charges and is held without bail. He now faces more than 60 counts related to the alleged sexual abuse of patients and non-patients. Prosecutors are urging women who believe they may have been victimized to contact the Queens DA's Special Victims Bureau. A two-day trial ended with a conviction in the case of a Little Rock toddler who was shot and killed during a road rage incident nearly 2 years ago. The court found Gary Holmes guilty of the murder of Asen King. The jury took about 30 minutes to reach the guilty verdict for Gary Holmes and an additional hour to decide on the sentence. Although the death penalty was not an option, the jury sentenced Holmes to 45 years in prison for the murder, plus an additional 5 years for related gun charges, totaling 50 years behind bars. Due to previous violent convictions, Holmes will not be eligible for parole. His attorneys noted that he turned down plea deals earlier this week, one for 80 and another for 40 years.
You have to take the wins with the losses. Mr. Holmes apologized to the victim's family. It's just a terrible, tragic incident, it's just one we'll have to live with.
Holmes plans to appeal his convictions. After the trial concluded, there was an emotional moment when Asen King's grandmother and Gary Holmes's mother embraced each other. Lucas County judge sentenced Darrow Cornelius, the final suspect in the 2022 murder of Demia Ezel. A representative for the family expressed that while they feel justice was served in court, no sentence can bring Demia back, and they're concerned this wound may never fully heal. Cornelius, 21, received a life sentence. He was found guilty of aggravated murder, attempted murder, and several other charges related to Demia Ezel's death. The prosecution presented evidence suggesting that Cornelius and an accomplice were aiming to kill Ezel's uncle, Kenneth White, in a drive-by shooting on Collingwood Boulevard. Instead, Demia, who was riding with White, was tragically killed. In their final statements, the prosecution argued for the maximum life sentence for Cornelius.
Perhaps in doing so, reinstitute some feeling of justice to her family and her friends and her schoolmates, but also send a message to other individuals in our community similarly situated that this type of violence cannot be tolerated.
Cornelius's defense acknowledged the severe impact of the incident on everyone involved, but requested one thing from the judge: the possibility of parole.
Which would give my client some hope, some positive motivation, that when he does go down to the institution, that he can do anything and everything that he possibly can to better himself.
Judge Stacy Cook granted Cornelius the chance for parole after 25 years. After delivering her sentence, she made a heartfelt plea to those in the courtroom.
It's got to stop. The deaths of children, the fear of children, they can't play in their yards, they can't play in their schools. You can't want this for your kids.
Speaking on behalf of Demia's family, Sean Mahone said that it's difficult for them to view this as a victory.
They wanted justice and they received justice, and they was very happy to know that he was found guilty. But it just took so much out of him because no one wins. At the end of the day, you have a young man that's going to prison for the rest of his life, and then you have a family that is still mourning the loss of the grandchild.
Despite receiving a longer sentence in Cleveland, the prosecution stated they don't believe Cornelius fired the weapon. Instead, they assert that his role as the driver makes him an equal and willing participant in Demia's death. A Coleraine High School teacher is speaking out against the student who attacked her in January. The teen, referred to as AB in court, was sentenced. The Coleraine Township detective who investigated the case described it as the most senseless and disturbing case he's ever seen. AB accepted a plea deal for felonious assault, which allowed his case to remain in juvenile court. Sherry Woolridge, the special education teacher, shared that the teen was upset about being in her class due to the shame it carried among other students. Woolridge spent 25 days in the hospital and underwent brain surgery following the attack.
Every day I wake up, something else hurts or something different hurts, or I'm stiff.
Baby steps, all right? Swing your legs.
When AB was arrested, Coleraine Township police body camera footage captured him saying he thought he was in a dream.
You know, in a dream, No, you're not dreaming, but we got you, all right?
AB's attorney claimed that before the attack, the teen had consumed THC through a vape pen given to him by someone.
What transpired was very serious and it was horrific, but I think there is nobody in this courtroom that can say that it was in part due to some type of substance that gave rise to a violent episode.
The prosecutor said blood tests revealed only a trace amount of the drug in AB's system.
He's telling some sob story to a school nurse that I took something non-bleaching, wake me up, while she's going to sleep. He lied to get away from the consequences.
I'm able to stand here today. Am I going to be able to do that in the future? Am I going to be able to walk and talk and take care of myself?
A state probation officer recommended sending the teen to a rehabilitation facility in Columbus. However, Judge Stacy ordered AB to be in the Department of Youth Services custody for 12 months, with 160 days already served. Taunton Mayor appeared in court, facing charges of assault and battery on a family member and assault with a dangerous weapon. She has pleaded not guilty to the allegations. Reports indicate that police were called to the couple's home after her husband claimed that the mayor bit him, struck him with a tool, and jumped on his car as he attempted to leave. He declined medical treatment following the incident. The couple released a statement over the weekend regarding the situation, which was referenced during their appearance in court.
We've issued a joint statement. We stand by that statement. I apologize for calling the police. I apologize to my wife and the people of Taunton. It was a huge mistake.
Taunton Mayor was released without bail and has been ordered not to abuse the victim. After Brittany Zamora received the minimum sentence of 20 years in prison, her lawyer aggressively criticized the outcome. In court, Zamora was seen crying heavily, expressing deep emotion.
We are here today, and Brittany knows that what she did was wrong. She does know, and she does accept it.
The media coverage of Brittany Zamora's case drew significant attention from her defense team. Zamora's mother mentioned that other family members were too frightened to speak in court due to the intense scrutiny and public attention surrounding the case.
However, given the publicity of this case, with the high media coverage, it puts not only their jobs but also their families at risk also to do so.
During the press conference called by Brittany Zamora's family and attorney, any remorse that might have been conveyed during the court proceedings seemed to dissipate. The focus shifted from the emotional aspects of the case to a more combative stance against the media and the legal process.
Not a predator. And this was not between a young child and Brittany. This was a teenager. The teenager had boundary issues and was obsessed with Brittany. The teenage boy was very aggressive. He even was very persistent in asking Brittany about her birthmarks, molars, or anything else that could be an identifiable piece of information. The teenage family's attorneys filed the civil suit within hours of the issue coming to light to the police department.
At the press conference, Brittany Zamora's lawyer read a statement that notably did not express guilt or remorse.
I feel like I was used as a publicity act to gain attention that was often driven by money, motivation from several parties.
Brittany Zamora pleaded guilty shortly after pleading for mercy, but her lawyer's subsequent refusal to answer further questions and the focus on media criticism overshadowed any expressed remorse. The timeline regarding the lawsuit reveals that while the notice of claim was filed in August 2018, the actual lawsuit was not initiated until early this year, contradicting claims of immediate legal action. Jonathan Smith, who initially agreed to testify against Leon Edwards in a road rage shooting case, backed out on his plea deal and chose not to testify. The shooting, which occurred in Cleveland, resulted in the wounding of a boy. Despite this, Leon Edwards was acquitted by a jury. At his sentencing, Smith apologized to the child's mother and expressed regret, stating that he was concerned about the potential impact on his own family if he had testified.
They traumatized us for the rest of our life. One got off, and one's still here. I'm not going to dwell on that. But I asked if you can see for him to get the max. Because you know what he did was wrong. Would a little better if he would went on with his plea. told the truth. Well, my baby only, he can't start like a regular kid. He in special ed. 7 different conditions he got to live with for the rest of his life. He done had 2 brain surgeries. I cannot work because I have to take care of my baby. Mother knows. Any mother. As a mother, you're supposed to protect your kids. That night I ain't had no control.
I understand what happened to her. Her kids was wrong. And I do apologize for what happened to her kids. But I'm not committed to doing it. But I really am sorry for what happened to them. I know she might not forgive me for not getting up there and doing what was right. I know I should have thought about her and her kids. But I was thinking about my family and what would happen to them if I get up on that stand and tell what happened. The wrong person is being convicted for this crime. If I could have stopped him that day, I would have.
In count 2 as amended, the felonious assault of Carter Hill. You're sentenced to 3 years on the specification to be served prior to and consecutive to 8 years on the felonious assault. On count 2, that is a total of 11 years. On count 5.
Your Honor.
Sit down.
Our family don't get to say
Can you please remove him from the courtroom? On count 5, the attempted felonious assault of Cecilia Hill, you are hereby sentenced to 36 months, 3 years, for a total sentence of 20 years. It may have been done at a prior hearing, but your supervision in case number 600095 is terminated.
Radoslaw Cherkowski, 36, was convicted of 12 counts of animal cruelty. He was sentenced to prison.
Radoslaw Cherkowski, please stand, sir. Having been found guilty of indictment number 2013-1094, offense 1, charging you with animal cruelty, in consideration of your offense, the court sentences you to be imprisoned at the Massachusetts Correctional Institution at Cedar Junction for a term of not more than 5 years, not less than 4 years. Having been found guilty of offense 3, charging you with animal cruelty, in consideration of this offense, the court sentences you to be imprisoned at the Massachusetts Correctional Institution at Cedar Junction for a term of not more than 5 years, not less than 4 years, to run from and after offense 001. Having been found guilty of offenses 4, 5, 6, 7, 8, 9, 10, 11, and 12, each charging you with animal cruelty, in consideration of these offenses, the court sentences you to be imprisoned at the Massachusetts Correctional Institution at Cedar Junction for a term of not more than 5 years, not less than 4 years, to run concurrent with offense 003. Having been found guilty of offense 2, charging you with animal cruelty, in consideration of this offense, the court places you on probation for a term of 2 years to begin from and after your release from the sentence imposed on offense 3. As special conditions of your probation, you are to not possess, no possession, custody, control, ownership, or contact with any dog, cat, horse, or other animal. You may not work or volunteer where animals are present. You may not participate in any program within any institution or elsewhere involving any contact with any dog, cat, horse, or other non-human animal. You are ordered to stay away, have no contact, direct or indirect, in writing or otherwise, with any witness, including relatives of Janina Stock or a prior owner of the dog, any veterinarian, police, or animal welfare officer involved in this matter. You have deemed to have served 104 days of the sentence. There is a victim witness fee of $90 that is imposed. You are notified of your obligation to submit to DNA sampling. You are notified of your right to appeal the convictions pursuant to Rule 65. You are notified of your right to appeal the sentence pursuant to Rule 64. And you stand committed, sir.
DeAndre Bonner, 33, pleaded guilty to multiple counts of rape and aggravated robbery for the November 2017 assaults on 2 women and a girl at a Cleveland RTA station. He was sentenced to 55 years in prison.
This was a clear act of control and power. It's what you think of when you think of a sexual assault. To rape 3 women at an RTA station, in a secluded area of the RTA station, with a weapon. Yes, it turned out to be a BB gun, but the women didn't know it was a BB gun at the time, Your Honor. These were 3 young women, 17 and 18 years old, that were just going to go out and live their life. They were going to go out and have fun with their friends. And they ran into this man. And to them and force your friends to watch you get raped at gunpoint. To say, don't say anything or I'll blow your brains out. It's the power and the control of a sexual assault that this man was exhibiting.
The only person he family is frontline. And that's what I was just going to get to, what he said. His family is frontline. Now, this isn't to excuse what happened here, because what happened here is wrong. He understands what he did was wrong, but it's a mentally ill person who was under the influence of PCP at the time, who doesn't remember what happened.
My heart goes out to the family. My prayers go out to the victims. I wish I could remember it, or, you know, just, I wish I would have knew what was going on. I wouldn't even been there. Only thing I remember is just going back to where I sleep at, outside St. Luke's building, because that's where I feel safe. And that's all I remember, Your Honor. I really am, I deeply am sorry.
Your Honor, I concede this defendant does have mental illness. I conceded that in my brief, and that is certainly mitigation this court should look at. But it's not the type of mitigation that should allow this defendant to excuse his behavior. We have people in our community every day that suffer from exactly what he is suffering from, that don't commit these types of acts.
Mr. Bonner, the facts of this case are considerably disturbing to me, extremely disturbing. The rape of the 3 women who were 17 and 18 years old at the time, some of them they were more than one time. The fact that they had to watch while you were raping their friends. The fact that you would rape one and then make another one perform oral on you. All those things are extremely troubling to this court. Because that each of these counts represent a separate action on your part, this court will run these counts consecutive for a total time of 55 years.
On September 4th, 2023, in Maple Heights, a woman named Mercedes Iverson, along with her husband and child, were tragically shot and killed. After an investigation, the police arrested Jason Iverson. When family members become murderers, the pain for others in the household is indescribable. Sometimes, our own relatives commit unforgivable crimes.
I don't know what was going through my mind when all of that happened. I just want to say that I'm very, very sorry. Truly, I apologize. And I just wish I could take it all back. Bring your son back, but I can't. And I'm here taking responsibility because I know that that was not the right thing to do. And to my mom, my family, I had wrote something down, but I'm truly sorry for taking Mercedes
away from us. It hurts like hell knowing that she's gone. I destroyed a whole family that day. I did. And I deserve whatever punishment that's coming toward me. She did so much. She did so much for everybody. They both did. They deserve to enjoy having a baby girl here and enjoying their own family. They deserve to live. And I should have died then. They didn't deserve none of this. And I'm sorry. I'm sorry I tore everything apart. Mom, I don't know how you could ever forgive me. I don't know how my family can forgive me. Whatever I was going through, you know what? They didn't deserve for me to take it out on them. They didn't deserve that. That wasn't me that day in the park, but it was me. Like my mom said, I was a different person. I don't know what went through my mind. I can offer no good explanation for what I did that day. I just pray and hope and wish that you could all forgive me one day. And know that I'm sincere about this and that I love and care about all of you. That's all I wish to say. Thank you, Your Honor.
Thank you very much. Thank you, sir. Anything further from the defense?
No, you're not.
Mr. Carter.
And I'm happy to see that. Thank you.
Lives were taken and lives were destroyed. You have 3 separate aggravated murder counts here. For the aggravated murder count number 1, Mercedes Iverson. There's a 3-year specification that is mandatory and must be served consecutively to the underlying aggravated murder charge. The court is well aware of all the different potential sentences pursuant to the aggravated murder sentencing statute. Each life affected here is as important as others. Each count is as important as others. For the aggravated murder of Mercedes Iverson, you would be sentenced to the term of imprisonment of life without parole. Anything less than life without parole would demean the seriousness of these multiple offenses. In a moment of your life, you forever changed. Everyone's life that knows, and everyone that you know, and everyone that you ever professed to love. Because everyone that you loved her. And I can't imagine what a mother with a child already named, who's 7.5 months pregnant with her, what thoughts were going through her mind as she lay bleeding out. aggravated murder charge. For count number 2, aggravated murder, where you did purposely and with prior calculation design cause the unlawful termination of Mercedes Iverson's pregnancy. Who was named by her and her husband as Ava. The court sentences you to a term of life without parole. For count number 3, for the aggravated murder of Norbert Carter, court sentences you to a term of imprisonment of life. For count number 15, the felonious assault of Junior. With this felony in the second degree, the court sentencing to a term of 8 years under the regular total sentencing scheme, which you're well aware of. 50% of your indefinite of that time will be definite period of time. Be an 8 to 12 year sentence. You're to serve a minimum prison term of 8 years with an indefinite prison term of 4 years on that count for a maximum prison term of 12 years. The total stated prison term for that count is 8 to 12 years.
We have a Karen who has been caught stealing and now faces the judge.
State of Texas versus Jules Alonzo. Can I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
Defense?
Ray Lopez for the defense, Your Honor.
And are you Jules Alonzo?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Alonzo, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with you're charged with theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Alonzo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
Can I have parties approach? All right, the cause number that it's having me taken in consideration is what she's pleading on. Does she have an outstanding case?
She has two cases, Judge, 5, 6, 7, 5.
All right, and to the clerk, I need the other file on Miss Alonzo, 2022 CR 7776. Oh, no problem. All right, according to the plea bargain agreement, Ms. Alonzo, the state is asking that your punishment be assessed at 6 months in the state jail facility. They're taking in consideration 2022 CR 7776. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
That's correct, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counselor, are there any such motions?
No, Your Honor.
Right. Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
At this time, the state introduces State's Exhibit number 1 and all of its attachments, Your
Any
Honor.
objection?
No, Your Honor.
All right, state, you may be excused to continue to confer. Thank you. Ms. Alonzo, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing? All right, and she's in yellow because, is she pregnant?
Yes.
All right, so why should I follow this agreement? Because 3 times she's been stealing and she's still stealing. And this time she's stealing greeting cards. So why should I follow this agreement?
Well, yeah, Your Honor, she's had an issue, a problem. She's pregnant right now. She's hopeless, not any dependencies or substance abuse, and she's asking for serve her time. And,
all right, what's your substance addiction?
I was addicted to heroin.
All right, so when did you stop using heroin?
They put me on methadone.
So you're currently on methadone. I always tell people, and I've done treatment courts, I've done studies, methadone is still a drug.
Yeah, I understand that.
So what are your levels on the methadone?
I'm on 30 milligrams.
All right, is Child Protective Services involved?
I'm not yet.
When are you due?
11/6 of this year.
Okay. All right, so I'm not going to follow this plea. If she wants probation, I will give her probation, and she's going into somebody's treatment program. I'm not going to have somebody out here having a child, and the child is going to end up being addicted to methadone. Let's just go ahead and say that right now, because if she's taking methadone, the baby's taking methadone. And depending on what level she's at on methadone, if I just release her, she's going to get out of state jail felony. She may start back using heroin. I don't know. I'm going to do my part. So hopefully the baby won't be born addicted. Have you ever seen a baby that's been addicted to
I have
substance?
2 kids and they've never been addicted.
Yeah. Well, by the grace of
God.
whoever. I'll just put it that way, because we have a separation of church and state here. But what I do know is that when babies are born addicted to drugs, they have withdrawals just like adults do. The only difference is that baby doesn't know why they're having withdrawals.
It wasn't my decision to get on methadone. It wasn't my decision to get on methadone. They put me on methadone as soon as I came in.
Well, here's the thing. It was your decision to use whatever drugs you were using, which was heroin. So that's all your decision. It's your decision to continue to pick up theft cases, knowing that you have 2 other children that you're supposed to be supporting. Where are those 2 children?
With my mom.
Yes. So your mom, instead of being a grandmother, she's happened to be a mother to your children. Was Child Protective Services involved?
Yeah.
All right. So were your rights terminated?
No.
All right. So I am not following this plea bargain agreement. If she wants probation, I'll give her probation, but I'm not following the plea bargain agreement for 6 months. She can either do 1 year at the state jail facility, or either she can be on probation for 4 years. The choice is hers.
We'd like to.
All right, thank you.
I'd rather be.
Yeah. Okay. You never mind, just rather take the probation.
I'd rather do probation so that way I can.
All right, so we're going to put this on the record. So have you had a chance to confer with your attorney?
Just right now.
All right, have you had sufficient time to confer with your attorney?
Yeah.
All right, so do you wish to have probation, or do you wish to consider the state jail facility for 1 year?
I'd rather do probation so I can see if I can be at least try to be a parent.
All right, any objections from the state?
No, Your Honor.
Defense, so is that the plea bargain agreement?
Yes, Your Honor.
All right, this is what the court will do. As previously stated, the court is finding there is sufficient evidence to find you guilty. The court will find you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. Taken in consideration 2022 CR 7776. I'm going to want intensive parenting classes.
I'd like to thank you.
There's to be no unsupervised contact with minors. Proof of employment within 30 days of release. I'm going to want a TAP evaluation while in custody. I'm going to run a referral to felony drug court while in custody. And since the day is Monday, felony drug court will probably be able to see you this week. You need to be honest with them. You understand? Okay. If she's not accepted for felony drug court, and if the TAP evaluation says she's to do inpatient treatment, then she's doing inpatient treatment. I'm going to want regular reporting by Zoom or in person. I'm going to want random UAs. I'm sorry, strike that. Do the UA hotline. And she needs to be tested at least once a week. And probation, please keep track of her methadone levels. They should not be going up. I'm going to want field visits 2 times per month until further notice. And probation, if you can make sure that they check to make sure that there are no children unsupervised at the location. And probation, if you want the field visits to count as her reporting, that can count as reporting. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. $200 hours of community service restitution. Those will be waived once parenting classes are completed. And CPS compliance if applicable. Probation, is there anything that I've missed? Is there anything you need from the court in order to be successful? I'm sorry? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Oh, and I'm sorry, also refer it to Esperanza Court as well, because of what I've seen in the background. So if felony, and that's to be while in custody. If felony drug court doesn't take you, then Esperanza Court will take you. Okay.
Finally, the judge offers Karen some advice.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? Yes. All right, we can go off the record. Ms. Alonzo, here's your chance. You got to stop doing many things, right? You got to go on the straight and narrow. You can't be stealing, because who knows, you may end up with a different judge, different prosecutor, different attorney. You understand? Yes. So if you want to be a mom in your children's life, you got to be a mom that they can be proud of. And when I say proud of, children will tease each other. You need to be that parent that your children will be proud to say, that's my mom, instead of being on the bus and hiding their head because they don't want anybody to know you're their mom. Okay. You still have a chance to do it, to get your life together. Good thing your mom has your children. Hopefully that's a safe place, and it's a safe place. So now's the time for you to get your.
This woman gets on the judge's nerves by not giving a straight answer and denying that she was using drugs despite testing positive.
So, ma'am, as to the allegation you tested positive for methamphetamine on July 1st, how do you plead?
Guilty with an explanation.
Okay, well, it's either guilty or not guilty. And counsel, I did hear you say guilty with
Not
explanation.
guilty.
But the explanation,
Not guilty.
the explanation, please don't interrupt me. The explanation will go towards whether or not I adopt the recommendation.
Correct.
All right, so guilty or not guilty, ma'am?
Not guilty.
So, Ms. Wisniewski, you're contesting the fact that you tested positive for methamphetamines?
Correct. Falsely.
Did we not discuss this not 20 minutes ago?
Yeah, I have a list of every single medication I took that day too.
Correct. So the question is, did you or did you not test positive?
Yeah, no, I did. Absolutely.
Okay. So was methamphetamines in your system? You tested positive for it, correct?
Correct.
Okay. So what's there to contest at this point? It was either in your system or it wasn't.
No, it was in my system, apparently.
Okay. So are you guilty or not guilty of having
No,
that?
I'm guilty. Guilty.
Okay, so ma'am, as to the allegation you tested positive for methamphetamine on July 1st of 2022 in violation of probation, how do you plead?
Guilty.
And you understand that you have the right to have a hearing in this matter, and by entering into a plea, you'll not have that hearing.
Yeah.
Is that yes?
Yeah.
I'm not one of your friends, ma'am. You're in court. Is that yes?
Yes, I said yes. Sorry.
I said yeah. I need it for the record. Yes, appropriately.
Yes, Your Honor.
You went over your advice of rights as it relates to your probation violation, correct?
Correct.
And did you promise you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
You understand the possible penalties as a result of your plea today, correct?
Yes.
That being probation could be revoked, or and also serving jail time, correct?
Correct.
Knowing all that, you still want to continue with your plea?
Yes, Your Honor.
All right, and counsel, if you can please refer to your client.
Sure. Ms. Wisniewski, are you currently on probation out of Wyandotte District Court?
Correct.
Did you in fact test positive for methamphetamines on July 1st of this year?
Correct.
Why did you test positive for methamphetamines?
According to my doctors, it was due to the medication I'm on.
Okay, what kind of medication would that be?
My Adderall, and I did take Sudafed and Benadryl that day as well.
Okay, but you do have a valid prescription for Adderall.
I do.
Okay, and that is prescribed from your treating physician?
Yes, I have the prescription right in front of me.
Okay, as a term and condition of probation, you understand that it could be a violation of probation if you did not have a prescription for Adderall.
Absolutely.
For it. Okay,
Yep.
Satisfied, Your Honor.
Have you submitted that proof of prescription to probation?
I did.
When?
After I tested positive, I got an official document from my pharmacy stating every single medication I was prescribed this month.
And what do you prescribe Adderall for?
I'm sorry, Your Honor, can you repeat that?
What are you prescribed Adderall for?
I have HD. I've been on it for over 10.
You're breaking up. You have what?
I have attention deficit disorder. I've been on it for over 10 years.
Well, why does it show up on some and not others? Some tests and not others.
I don't take it every day, Your Honor.
I'm sorry?
I don't take it every day. I only take it.
You take it when?
I only take it when, like.
You're breaking up again, ma'am.
I apologize. I only take it when I feel like I need it.
Oh, okay. I'm gonna tell, no way, ma'am, absolutely not. Am I going to buy the fact that you're on a prescription medication like Adderall and you only take it as needed? Because that's a medication that you can't just stop cold turkey. There needs, you can't just take it, not take it, take it, not take it. Absolutely not. Is that a medication you can do that with?
I've been doing that for years, Your Honor.
Well, have you told your doctor about that?
Yeah, she said that's fine. She said take it when I need it. I never have withdrawal or anything from not taking it.
Yeah,
Well, if you have attention deficit disorder, ma'am, and it's not severe enough to take Adderall on a daily basis, then perhaps you need a different medication that isn't as strong, excuse me, as Adderall, and one that would not have any effects otherwise or not when you're taking it, not taking it, taking it, not taking it. The court's going to accept your plea of guilty of the probation violation. And counsel, I hear what you're saying, what your client's saying about her prescription, but she is definitely not taking the Adderall as prescribed.
well, it doesn't sound to me like she's abusing it in any sense. It sounds like she's just taking it here and there when she feels necessary.
Well, which to this court would make it seem as though she doesn't really need the Adderall and she's taking it when she wants to take it for the effects of the Adderall. Ma'am, if you were tested today, what would be detected in your system?
My pain medication, and Adderall.
I'm sorry, your pain medication? What medication are you taking for pain? I'm sorry?
Norco and Adderall.
How long have you been taking the Norco?
A little over a year.
And is that the same doctor that prescribes it, that prescribes your Adderall?
No, it's my orthopedic surgeon.
And so when was your prescription last refilled?
Today, this morning.
This morning?
Yes.
And so did you already go pick it up?
Yeah, I went and got it around 9:30.
And so how long is that prescription for? 14 days, 21 days, 30 days?
I get it filled every 2 weeks.
Every 2 weeks. And so did you already take your 2 for today?
No, I only took 1.
Okay. So go grab your pill bottle, please. I'd like to see how many are in there. Oh, go ahead. What's that?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 19, 20. I have 28 here.
Okay. So the one you took this morning was from the last prescription?
No, it's from this one.
Well, if it's for 14 days times 2, isn't that 28? And you said you already took one this morning.
I did. I get 29 every 2 weeks.
And what about your Adderall?
I got
How
this.
often is that refilled?
I can take it twice a day. I got it filled on the 15th.
Of July?
Yes.
Okay. And how you get that prescription filled how often?
Once a month.
So there should be 60 pills less
There was
10
60 when
days.
I got it.
Okay, so how many do you have in there now? Turn the camera on so I can watch you count it, please.
Okay, I counted. That's all I have on me, yes.
So that's 19 right there. Is that what you counted?
Yes, I counted 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Yes, 19.
Okay, so you get these filled every 30 days, so there should have been 60 in there. Because you just, when you received, you refilled it July 15th. Where you had 60 pills in there. It is July 25th, so that would be even 11 days, right? You've been taken in 11 days. The 15th, 16th, 17th, 18th, 19th, 20th, 21, 22, 23, 24, 25. Okay? 2 times a day, that's 22. When you subtract 22 from 60, what do you get, ma'am? I'll tell you, you get 38. Okay, and really, right, I'm giving you the full benefit, the full day today. So that would be 38. And you only have 19 left. You just filled this prescription 10 days ago. And you just got done testifying to this court that you don't take them every day.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.